Hi, everybody. Thank you all for coming. We're going to start tonight with an opening prayer from Father Aquinas, and then we'll hear some welcoming remarks from Dean Payne.
In the name of the Father, and of the Son, and of the Holy Spirit.
Amen.
Heavenly Father, you wondrously created us in your image, and even more wondrously, you redeemed us in Christ. To justify and heal our fallen human nature, your Son took flesh in the womb of the Virgin Mary. As your Son's mother and his first disciple, Mary reflected perfectly and sinlessly the justice won for us on Calvary. As a result, the beauty of the face of Mary is the beauty of the face of Christ. Through the intercession of Mary, mirror of justice, bless our gathering this evening. Make us hunger and thirst for the justice of your Son. May we become not only ministers of justice, but also, like Mary, true reflections of your justice in the world. We ask this through Christ our Lord. Amen. The Father, and the Son, and the Holy Spirit.
Thank you, Father Aquinas, and thank you all for joining us. It's my great pleasure to welcome you to the Law School and the Mary Mirror of Justice lecture. I want to thank first the students, the St. John Paul II Guild of Catholic Lawyers, for their excellent enthusiasm and engagement and thought that's going into the program at the law school this year. I think there's a lot more great things to come from them, and I think that's a real asset to our school. It also, well, first let me apologize. Don't be offended when I actually have to leave, because I've already mentioned this to Emily and to Elizabeth. I have a lot of important work left to do tonight, not nearly as much fun as what this would be, so I'd much rather be here, but duty calls. Let me just say that Mary Mirror of Justice, it's a really important image for us as a law school. Obviously, justice is one of the incredibly important virtues, and something that we think about a lot as law students and lawyers, and hopefully something that we're trying to model and engage in achieving when we are in practice and in life. And Father Aquinas pointed out to me that our chapel, Mary Mirror of Justice, is the only Marian chapel on campus. Now, obviously, we're right next door to a pretty big Marian shrine, but nonetheless, it is the only one on campus, and that's very, very special. We're starting to talk about ways that we could acknowledge that in a special way in the chapel. So hopefully more to come on that. And finally, it's no surprise to me, Emily's going to introduce Elizabeth, but it's no surprise to me that Elizabeth Kirk is being honored with this lecture today. Since she has come to the law school, I've really been as happy as I could be with what she has done for the school and its students, and standing up as the inaugural director of our Center for Law and the Human Person, which has become a really important aspect in expressing our identity and mission, and in thinking about what our Catholic identity and mission should mean to legal education and legal practice. In her many appearances in the media and writing about important topics, and arranging for lecture series and conferences, academic conferences on adoption, just recently, for example. Her teaching family law and lawyering skills last term and our last year, and all sorts of other things that demonstrate what a team player she is. But most of all, I've been impressed with her concern for our students and her engagement with them, and her interest in our students' well-being and formation and vocations. And That has been shown in spades. She's already, in her short time here, been elected by the students to be their marshal at commencement last year, that the person to stand up and read their names. That's such an important role. And now, she's being honored with this Mary Mirror of Justice lecture, and it's a wonderful testament to what she stands for in representing our school. And I commend the students on their selection, and congratulate Elizabeth. And with that, I'll turn it back over to Emily, the president of the St. John Paul II Guild of Catholic Lawyers at our school, Emily Johnson.
Thank you, Dean Payne and Father Aquinas. Good evening, everybody, and welcome to the annual Mirror of Justice lecture and presentation of the Mirror of Justice Award. My name is Emily Johnson, and I'm the president of the St. John Paul II Guild of Catholic Lawyers here at the law school. The St. John Paul II Guild of Catholic Lawyers, which I'll just call the Guild for the sake of my sanity this evening, is an organization dedicated to the promotion of justice in the law and protection and advancement of the intrinsic value and dignity of the human person. Through the study of Catholic social and moral principles based on the authoritative teachings of the Catholic Church, the Guild seeks to aid students in discovering ways of applying these principles in their practice of law and in society more broadly. Among other annual events, the Guild hosts this lecture series, which was inaugurated in 1989 to honor Mary under her title Mirror of Justice. The series is intended to recognize and encourage lawyers and scholars who, through their scholarship and dedication to teaching, clarify and advance the pursuit of peace with justice through the law. Our namesake, St. John Paul II, of course, had a special devotion to our Blessed Mother. Watching his people in Poland suffer under communism, the Pope preached a special message on the feast of Our Lady of Częstochowa, which I found especially fitting for tonight. He said, "My dear compatriots, however difficult the lives of Poles may be this year, may consciousness win in you that this life is embraced by the heart of the Mother. As she won in Maximilian Kolbe, so may she win in you. May the Mother's heart win. May she ensure that we shall not desist from trying and struggling for truth and justice, for liberty and dignity in our lives." The struggle for truth, justice, liberty, and dignity are central to the Guild's mission, and central too to the annual lecture and award. This year, our board was excited to choose a professor whose work and mission reflect these values, and we were honored when Professor Kirk agreed to deliver the remarks you'll hear tonight, entitled Reflecting Our Lady, Radical Hospitality to the Child. Professor Kirk was an obvious choice for our board, and though she needs no introduction, I'd like to highlight just a few of the many accomplishments Professor Kirk has to her name. Professor Kirk joined the Columbus School of Law after serving as the director and Kowalski Chair of Catholic Thought at the Institute for Faith and Culture at the University of Kansas. Prior to that position, Professor Kirk was the Associate Director of the Notre Dame Center for Ethics and Culture, an interdisciplinary center which, fittingly, is inspired by the teachings of St. John Paul II and dedicated to bringing the Catholic moral, intellectual, and cultural tradition to bear on the formation of students. Additionally, Professor Kirk served as a consultant to the United States Conference of Catholic Bishops Pro-Life Committee under Archbishop Naumann. Currently, in addition to her positions as a research associate and lecturer at the law school, Professor Kirk is the director of the law school's Center for the Law and the Human Person, an associate scholar at the Charlotte Lozier Institute, and a faculty scholar at the Catholic University of America's Institute for Human Ecology. Professor Kirk's scholarship explores the relationship between the Catholic intellectual tradition and law, with a special focus on matters pertaining to the family and adoption law and policy, which is of course fitting for tonight. So without further ado, the Guild is happy to hand over the mic to Professor Kirk.
Thank you. Thanks to Dean Payne, who's still here. I was especially happy for your remarks because my kids might actually think I'm kind of cool. So I appreciate your remarks and your presence. Also, Father Aquinas, thank you. And a deep expression of gratitude to the members of the Pope John Paul II Guild of Catholic Lawyers for this tremendous honor. I am incredibly humbled by your choice, and especially to be among the list of the distinguished recipients over the years. As Emily's generous introduction indicated, I have had a rather unconventional career path with a number of different positions, and I like to tell my students that my CV is evidence of all of the things that you can do with a law degree. My students, those of you who've been my students, know that my daughter Alice's advice to me for being an interesting teacher is to serve candy, show videos, and bring Chewy, our dog. And I'm not going to do any of those things tonight, so you'll have to bear with me. Throughout all of the roles in which I've served, but in a special way in the classroom, I have found inspiration and hopefully a unifying theme in the description of university life set out by Pope John Paul II in Ex Corde Ecclesiae. He says, "The ardent search for truth and its unselfish transmission to youth and to all those learning to think rigorously so as to act rightly and to serve humanity better." So together with my students, my task in studying law is to search for truth. And as their teacher teaching law, it is to transmit it to them as best I can. But the fruit of this search for truth and its transmission is right action and service of humanity. Therefore, our scholarly pursuits together are never purely academic. Or as Professor Drinan, a past recipient of this award, put it in her book, The War on Kids, "My scholarship is useful only if it contributes to the common good and gives voice to those who don't otherwise have one." So that is what I endeavor to do in my own scholarly work and public policy work in the classroom, and as director of the Center for Law and the Human Person, and what I encourage all of you to do in your vocation to law. The phrase "the human person" communicates that the center's mission is to explore law, the foundations of law, what justice means, the meaning of the common good, to explore all of these things in relation to Christian anthropology. That is, what we believe to be true about the human person, his or her nature, his or her good, his or her ends. In its earliest conception, a slightly different name was proposed for the Center for Hospitality to the Human Person. This name didn't catch on, perhaps because it sounded like we were trying to found a center for hotel and restaurant law or something like that. But I will briefly reflect upon that word because it animates the center's mission and, as my title makes clear, relates to my remarks this evening. In the Old Testament, hospitality was the sacred obligation to welcome the stranger and to provide him with food, comfort, or protection. This mandate was not merely a matter of what we might today call social justice, but above all was an obligation on the Israelites to show mercy to strangers as an expression of gratitude to God, because he had first welcomed them, for they were strangers once in Egypt. In the Christian tradition, hospitality was integral to the practice of faith. St. Paul encouraged the Hebrews, "Do not neglect to show hospitality to strangers, for thereby some have entertained angels unawares." Hospitality, thus understood, is ordered towards God, motivated by gratitude to him, and extended to others, especially the stranger, because they bear the divine image. Pope St. John Paul II described this orientation to the other, this radical hospitality, as the law of the gift. Notice that he called it the law of the gift. So it's not merely an ethical practice or an aspirational ideal, but a law, a truth about the human person. We are fashioned through pure gift. In the image and likeness of God, a triune God, three persons engaged in eternal self-gift, and we were made to give ourselves to one another and him in return. The life of the second person of the Trinity, Jesus Christ, reveals this most perfectly, culminating in his death on the cross. Self-gift, making ourselves vulnerable to others in our fallen state, will involve suffering. And yet the cross teaches us that it is in suffering that we become capable of love in its fullest form. As Pope Benedict said in Spe Salvi, it is not by sidestepping or fleeing from suffering that we are healed, but rather by our capacity for accepting it, maturing through it, and finding meaning through union with Christ, who suffered with infinite love. In every recorded event of her life, Mary, for whom this lecture is named, demonstrated this outward orientation, this gift of herself to and for the other, for God, such as in the Annunciation, where she gave her fiat to the will of the Father, or in the Visitation, where her obedience to God immediately manifests itself in service to her cousin in need. "My soul magnifies the Lord," she proclaimed. This was true even to her faithful presence at the foot of the cross as her heart was pierced by a sword. Reflecting her, we, too, are, as Pope John Paul II said, at our best. We are most fully alive and human when we give away freely and sacrificially our very selves in love for another. So in light of her example, I would like to offer a perspective from family law regarding how the law ought to prioritize the good of the other, the child, and how adoption in particular can be a way of practicing radical hospitality to the child vis-a-vis abortion and in the context of foster care. I will proceed in 4 parts and in an interdisciplinary fashion. So first, I will briefly describe the contemporary crisis of what we might call orphans of the living. Second, I will reflect on the phenomenon of adoption, drawing on the Catholic intellectual tradition. Third, I will identify particular barriers to adoption in the US. And then finally, I will conclude by offering comments on the role of law, and in particular highlight a couple of things I've done in this regard. So first, the contemporary crisis of the orphans of the living. Of course, sadly, there are many ways in which children are vulnerable to exploitation and suffering today. So in this lecture, I am only focusing on 2 contexts, the child languishing in foster care and the child at risk of abortion. Children in foster care, deprived as they are of the care and protection of their parents and in need of temporary or permanent homes, are often referred to as orphans of the living. This phrase also may describe the child at risk of abortion whose mother, for whatever reason, feels unable to welcome her. First, the foster child. In 2021, there were 391,098 children in state-run foster care in the United States. The number of children in foster care has declined only slightly since its peak in 2018, itself caused in part by the opioid crisis, which creates a higher likelihood of the conditions of abuse and neglect. Most children, though, interestingly, in the state's care are not victims of physical or sexual abuse. 63% of children are removed by the state based on allegations of neglect, which often arise out of circumstances of poverty, which are arguably preventable. 21% of the children entering foster care in 2021 were under 1 year of age. Children in their first year of life have the highest rates of victimization, and nearly half of child fatalities are younger than 1 year old. The goal of the foster care is to reunify children with their parents, and therefore the state has an obligation to provide services to families to help parents rehabilitate themselves while their children are in state care. But this goal of reunification is met in less than half of the cases. In 2021, only 47% of children exiting the foster care system were reunified with their parents. A small number, 6%, were placed with relatives. 25% found permanent adoptive homes. Nearly 20,000 children, 9% of those exiting the system, aged out, becoming adults without having been reunified with their parents or finding a permanent placement. Re-entry is also a significant challenge, as among children who were discharged from their first foster care placement and reunited with their parents, 27% returned to care. This risk of re-entry is highest at 2 points, in infancy and then again in teenage years. Lengthy stays in foster care, what is meant to be temporary, are known as foster care drift. On average, children exiting the system spent nearly 2 years in foster care. 17% were in care for more than 3 years. Even once the parents' rights have been terminated, which is the legal act making them eligible for adoption, a child waits an average of 19 months after termination to be adopted. That child waiting to be adopted has already spent an average of 33.7 months in foster care and is on average 7.5 years old. Next, the child at risk of abortion. Pregnancy statistics are difficult to measure, but there are an estimated 6.1 million pregnancies annually in the US. 45% of pregnancies are unintended, and approximately 42% of those unintended pregnancies end in abortion. In 2020 in the US, there were 3.6 million live births and 930,160 abortions. The abortion numbers are based in part on estimates, as self-managed abortions are not included in these counts, nor are medication abortions fully accounted for, and those now constitute the majority of US abortions. So the actual number is likely much higher. And it remains to be seen, of course, what the impact of Dobbs will be, whether women will travel to jurisdictions that protect abortion access or instead bear children that they might otherwise have aborted or don't feel ready to parent. A Guttmacher study found that the decision to have an abortion was typically motivated by multiple reasons, which include having a child would interfere with a woman's education, her work, or her ability to care for existing dependents, that she could not afford a baby now, that she did not want to be a single mother or was having relationship problems. Nearly 4 in 10 women said they had completed their childbearing, and almost 1/3 were just not ready to have a child. While poverty certainly plays a role, rates of unintended pregnancy are much higher among those below the federal poverty level. It's not a simplistic correlation, as abortion rates are much lower among poor women. Adoption is not a meaningful option for women facing unexpected pregnancies. So while the number of abortions in 2020, as I said, was nearly 1 million, the number of infants placed for adoption in that same year was 19,658. So for every 1 infant placed at birth for adoption, 50 are aborted. Throughout my career, I have worked to explore whether adoption serves as a meaningful option, an expression of the law of the gift, for those unprepared for parenthood, who think abortion is their only or best option, or for parents who are at risk, whose children are at risk of languishing in foster care. And I want to be clear here that I am proposing that adoption is a way of practicing radical hospitality to the child, and I do not mean to exclude other vital, even primary responses to these crises besetting vulnerable children, especially those of shoring up the family and providing resources and support networks for mothers and fathers so that they can more readily welcome and safely rear children. Pope St. John Paul II, I feel like I need a shorthand for that phrase, described adoption in this way: to adopt is a great work of love. When it is done, much is given, but much is also received. It is a true exchange of gifts. His use of the word gift to describe the experience of adoption, which is so central to his intellectual and spiritual work, is significant. If the law of the gift is the truth of the human person, how much more should we be willing to sacrifice ourselves when the good of children is at stake? The late Francis Cardinal George put it this way: give and take, tit for tat, pay to play, so many of the normal ways of dealing with things don't apply when it comes to children. No one deserves to be born, and no parent deserves a child. Life is pure gift. It speaks to us of God, who is pure generosity, pure self-giving. This truth about the human person stands in stark contrast to the individualism embodied in American law. Many today view adoption through a lens of whether it serves adults. So, for example, some think adoption is primarily a way for adults to have children. especially if they are unable, for whatever reason, to conceive and bear them. For example, the godfather of the legal and intellectual framework of artificial reproductive technologies, the late law professor John A. Robertson, argued for the individual's right to procreative liberty, not limited to the right of Roe and Casey to avoid parenthood, but as a positive right to form families. And he proposed that a robust procreative liberty might one day loop back and redefine the way all reproduction is viewed, even so-called normal reproduction, or existing restrictions on practices like baby selling, leading, he hoped, quote, to a widespread market in paid conception, pregnancies, and adoptions. On the other hand, some critique adoption as inherently exploitive of parents, describing continuing a pregnancy only to place the child for adoption as forced pregnancy or a form of coerced surrogacy. The dissenting justices in Dobbs articulated the view that adoption does not lessen the woman's need for abortion because, quote, the reality is that few women denied an abortion will choose adoption. The vast majority will continue to shoulder the cost of child-rearing. Whether or not they choose to parent, they will experience the profound loss of autonomy and dignity that coerced pregnancy and birth always impose. Similarly, a prominent adoption scholar, Professor Michelle Merritt at Arkansas State University, asserts that, quote, rhetoric positioning adoption as a reproductive choice or an alternative to abortion is a denial of bodily autonomy. Both the Robertson view of adoption as serving adults' desires for children and Professor Merritt's view that adoption is a per se denial of the woman's autonomy share the individualist perspective of viewing adoption solely through the lens of the adults. In contrast, then, let us interpret the phenomenon of adoption as ordered toward the good of the child in light of the law of the gift. Contra the contemporary view of pregnancy as implicating only the woman's individual autonomy interests, this view holds that a pregnant woman is in relationship with, not antagonistic to, her child, and has certain duties and obligations that exist which orient her to the good of the child and thereby to others. As St. John Paul II put it, this unique contact with the new human being developing within her gives rise to an attitude toward human beings, not only toward her own child, but every human being, which profoundly marks her. St. John Paul says of a mother placing her child for adoption that much is given. And I would say in some sense, all is given. Fulfilling her duties to her child as best she is able by protecting her child's life by continuing the pregnancy, and then placing that child for adoption, despite the personal suffering it involves, is the most radical gift of self to and for another one can imagine. We might even call it a paradigmatic act of the law of the gift, as this orientation toward the good of the child is the mark of the unconditional love of a parent. Social science studies confirm that women who choose adoption are those best able to separate their children in their minds from themselves in order to arrive at a decision about what is best for their children. When birth mothers are able to see their babies as unique persons with their own rights, desires, needs, and possibilities, they are better able to determine what is best for them. What do birth parents receive in this exchange of gifts? They may feel judged or marginalized by others or have fears related to the decision itself, such as concern over the child's future reaction or distress at the prospect of separating from a child she is bonded with. But many birth parents witness to the healing potential of adoption. For example, one woman stated, "Adoption gave my life purpose. I was a misguided teenager headed in the wrong direction. Giving my daughter up for adoption gave me the motivation to continue my education, go to college, and follow my dreams. I was able to do this because I did not want to let her down. I did not want my daughter to think I gave her up and then did nothing with my life. I wanted her to be proud of me. Another mother writes, I am more confident than ever of my decision to choose adoption. I am feeling a sense of peace. It is such a consolation to know I have made a good decision for both me and my child. Of course, there are those who regret their decision to place a child for adoption or who feel in retrospect that their choice was not voluntary. Interestingly, however, this seems to be a phenomenon especially associated with former practices of adoption that took place in secrecy and shame. In the baby scoop era, closed adoptions were the common practice. Women facing unexpected pregnancies would temporarily move to another location, have their babies in secret, and return home. The doctor or child placing agency would then find an adoptive family, unbeknownst to the mother. This led to obvious complications in the lives of the adopted child, who was often ignorant of and had no access to understanding her identity, and also of the mother, who had little agency in the process. This is far different from contemporary adoption practices, which are typically open and in which mothers have a great deal of agency. According to one study, younger birth mothers felt they had made their decisions voluntarily, and as a result, they owned their decisions, feeling empowered and right about it. Turning to the adopted parents, the most obvious way in which adoption involves a gift is that the adopted parents receive the gift of a child. 3 of our 4 gifts are here today. When the adoptive parents receive the gift of a child, it disabuses all parents of the notion that a child is something to have. Adoption manifests this reality in a distinct way because there is no obvious act of co-creation of the child. But consistent with the Church's teachings on responsible parenthood, adoptive parents, like all parents, ought not to seek to have children, but to receive children as pure gift. Adoptive parents may be motivated to pursue adoption out of desire for a child, but the end must be oriented to the good of that child and her parents. And this outward orientation must be offered selflessly, even if the birth mother in the end decides to parent. It is important to say here that adoptive parents must never objectify birth parents as a means to a child. Adoptive parents must be attentive to adoption's profound potential for empathy and love to the birth parents at every stage of the adoption process and thereafter. What do adoptive parents give? Of course, they give a home, love, and support to a child. But it is something more. Adoption is a way to live the biblical mandate of hospitality because it is a radical welcoming of the stranger, not only making a meal or space for that person as a guest, but making a home for that person as a son or daughter. Pope John Paul said, adopting children, regarding and treating them as one's own children, means recognizing that the relationship between parents and children is not measured only by genetic standards. Procreative love is first and foremost a gift of self. There is a form of procreation which occurs through acceptance, concern, and devotion, and the resulting relationship is so intimate and enduring that it is in no way inferior to one based on a biological connection. Adoption is truly then, I would say, with John Paul, an exchange of gifts. Through the radical self-gift each makes to the other in adoption, both birth parents and adoptive parents conform themselves to Christ, the image of divine love, from whom our human dignity finds its origin. And in doing so, their sufferings may bear fruit. Third section. If adoption is an expression of the law of the gift, and should play an important role in responding to the crises of foster care and abortion, what barriers exist to it? Adoption has a very strong public reputation, and for a long time it has been viewed as common ground in the fraught culture wars over abortion. Pro-adoption legislation is often bipartisan, and the Congressional Adoption Caucus is the largest bicameral caucus. And yet, the reality is that adoption is the last resort in the foster care system and is disfavored as an option for both women facing an unexpected pregnancy and for families who might otherwise welcome children into their home. In the foster care system, which prioritizes family reunification, adoption is explicitly a last resort. And while this goal of supporting and rehabilitating natural families is appropriate, as the data I shared indicates, too often it means that children are not made eligible for adoption by safe and stable families while they are still adoptable. I'll say more about that in a minute. But the law seemingly prioritizes permanency. The Adoption and Safe Families Act, for example, requires states to move to terminate parental rights if the child has been in foster care for 15 of the last 22 months. There are exceptions to this rule, but the fact that children are in foster care for an average of nearly 22 months and that 17% are in there for more than 3 years demonstrates that this law is failing to achieve its goals for children. Having experienced removal from their families under circumstances of trauma, abuse, or neglect, followed by years in the foster care system, many children require a forever family with special resources who can meet their resulting needs, which are often profound. Other children may have significant medical needs or be part of a sibling group. As the number of children waiting to be adopted indicates, many children are hard to place. Numerous other barriers to adoption in the child welfare system exist, including interjurisdictional legal barriers, insufficient post-adoption support, delays relating to poor case management or staff turnover, etc. In the context of unexpected pregnancies, as I said, adoption is not a meaningful option for women. Statistically, as the 50-to-1 ratio indicates, it is so rare as to be a non-option. Why is this the case? What barriers are there to adoption playing a more robust role vis-a-vis abortion? There are many complex factors that impact women's decision-making, so I will just highlight a few. A chief factor is that adoption requires the woman to continue her pregnancy, and therefore abortion is preferred because it provides a more immediate resolution. One study found that adoption was considered the most evil of the 3 choices. The study was summarized in this way, that adoption is perceived as a double death. First, the death of the self, as the woman would have to accept motherhood by carrying the baby to term. Further, not only would she be a mother, but she would then perceive herself as a bad mother, one who gave her own child away to strangers. That abandonment is the second death. That leads to the second barrier, which, despite the strong public approval of the institution of adoption, there is a stigma against the actual choice of it because adoption is viewed as abandonment or as unnatural. For example, one study participant who chose abortion shared, "I don't want to have to know that I had a child out there in the world or whatever, that I had done gave my baby away. No, I just felt either more comfortable with terminating it or just keeping it. I was not ever going to do adoption. It's not an option for me." Another qualitative study examining barriers to adoption among pregnant teens in DCFS, so pregnant teens who themselves are in foster care, found that there is a bias that precludes teen mothers from giving adoptive placement equal consideration. So, for example, the author recounts the example of one young woman who had decided to make an adoption plan, but she pretended throughout her pregnancy that she intended to parent. And then when she came back to the home without the baby, she made up a story for her housemates that the baby was forcibly removed by the local CPS, Child Protective Services, and put into foster care because that was a more acceptable story to tell her housemates than to admit she had placed her child for adoption. In another study, women surveyed about their reasons to choose abortion volunteered that they had considered adoption and concluded it was a morally unconscionable option because giving one's child away is always wrong. Even among those who have chosen to place a child for adoption, 61% of birth parents feel that there is some stigma associated with their choice. A lack of education about what adoption involves is also another factor. One study analyzing women's motivations to abort stated that without being asked directly, several of the women indicated adoption is not an option. They reported that the thought of one's child being out there in the world without knowing if it was being taken care of or by whom would induce more guilt than having an abortion. So surely I think this also reflects the reality of the painfulness involved in relinquishing one's child, but it also demonstrates that serious misunderstandings exist about the contemporary practices of adoption, such as that families who place a child will have no contact or even know where she has been placed. Others conflate adoption with the foster care, saying that they reject adoption because they don't want their child in the system, not realizing they're two separate systems. Finally, there are also barriers to welcoming a child into one's home through adoption. In fact, adoption is rarely chosen as a way to build a family. While more than 33% of Americans state that they've thought about adopting a child, only 2% actually adopt one. Obstacles include the exorbitant financial cost of domestic infant adoption. One can expect to pay anywhere from $15,000 to $60,000. The required paperwork and scrutiny of the home study process, the uncertainty of the matching process, the painful possibility that a birth parent might change her mind once matched, or fears related to parenting or bonding with a child that is unrelated. Of course, there are disparities between available adoptive parents in the context of newborns compared to older children waiting in foster care. While we know that there are children waiting for forever homes in foster care, there are nearly 40 families waiting for every available newborn. We might decry this imbalance, but it is not difficult to understand why prospective parents might feel able to welcome a newborn, but not an older child who bears the trauma of neglect or abuse and has bounced around foster care. In the foster care context, there is a near constant shortage of foster homes. The number of licensed foster homes in this country is 214,321, far less than the number of children in state care. Last year in DC, there were 505 licensed foster homes, but 648 children in care. While many Americans say that they have considered foster parenting, fewer than 10% of those who begin the process of becoming foster parents become licensed, and 1/2 to 2/3 of foster parents leave the system within a year of becoming licensed. And there are significant barriers to recruiting and retaining foster families, which include a poor public perception of the foster care system, cumbersome and arguably excessive licensing requirements, burdensome training requirements, unnecessary home requirements, and a lack of adequate post-placement support. My final section, the role of the law. In light of the truth that the human person was made for self-gift and that adoption can be an expression of this truth, what can the law do to overcome these barriers and to promote adoption in these contexts? At the outset, I will say, although it's beyond the scope of my remarks to explain fully why, we must affirm that law, which guides human conduct and is meant, according to Aquinas at least, to make human persons good, that law should be based on proper assumptions about the nature of the human person. This nature, who we are, what we are made for, is accessible to us through reason, as scholars like Professor Carter Snead sought to do in his book, What It Means to Be Human. There, he described man's nature as embodied and dependent, and the role of law, he said, was to promote and protect those, quote, networks of uncalculated giving and graceful receiving on which we all depend for our survival and flourishing. The paradigmatic case that most clearly demonstrates this fuller vision of the human person and which ought to be protected in law is the relationship between parent and child, in which parent accepts the child as pure gift and the good of the child is both paramount and unconditional. So although Snead doesn't cite Pope John Paul II, this secular account of the importance of basing law on the truth of human nature as revealed in our embodiment is remarkably similar to the law of the gift. In the context of children, the law ought to prioritize the good of the child due to her inherent dignity, her vulnerability, and her embodiment of the common good. I don't think there has ever been a better description of the truth that law and public policy should be oriented toward children than G.K. Chesterton's description of a little girl's hair at the conclusion of What's Wrong with the World. How many of you, out of curiosity, know this quote? My husband is raising his hand. Well, then I'm going to read the whole thing. I've kept you long, but this is worth hearing, I think. G.K. Chesterton says at the end of his book of essays, "I begin with a little girl's hair. That I know is a good thing at any rate. Whatever else is evil, the pride of a good mother and the beauty of her daughter is good. It is one of those adamantine tendernesses which are the touchstones of every race and age. If other things are against it, other things must go down. If landlords and laws and sciences are against it, landlords and laws and sciences must go down. With the red hair of one she-urchin in the gutter, I will set fire to all modern civilization. Because a girl should have long hair, she should have clean hair. Because she should have clean hair, she should not have an unclean home. Because she should not have an unclean home, she should have a free and leisured mother. Because she should have a free mother, she should not have a usurious landlord. Because there should not be a usurious landlord, there should be a redistribution of property. Because, you probably didn't think I was going to say that. Because there should be a redistribution of property, there shall be a revolution. That little urchin with the red gold hair, whom I have just watched toddling past my house, she shall not be lopped and lamed and altered. Her hair shall not be cut short like a convict's. No, all the kingdoms of the earth shall be hacked about and mutilated to suit her. She is the image, the human and sacred image. All around her, the social fabric shall sway and split and fall. The pillars of society shall be shaken, and the roofs of ages come rushing down, and not one hair of her head shall be harmed. Historically, law has expressed this orientation to protect the vulnerable, including the child. Examples abound. I'll just mention a few. The UN Convention on the Rights of the Child affirms that the child, by reason of his physical and mental immaturity, needs special safeguards and care, including appropriate legal protection before as well as after birth. Another example is the protection of the fundamental rights of parents under U.S. constitutional law, which are necessary because parents have the duty to protect and raise their children. Another example would be the common law doctrine of parens patriae, which allows the state to intervene to protect the child in cases of abuse and neglect. In family law, children are prioritized as well in various ways, but chiefly in the privilege and protection of marriage, because the stable, permanent conjugal bond was understood to be the best place to welcome and raise children. And in this order, adoption was understood to be an exceptional remedy to provide a home for a child in need. In other words, adoption was child-centered. Now, however, there are fewer special features of marriage in the law, and it no longer has a necessary connection to children. The need to answer various questions raised by artificial reproductive technologies, especially the question, who is the parent, gave rise to what might be called a redefinition of parenthood based on intention. Adoption, which was the only intent-based form of parenthood contemplated by the law that contemplated as a remedy, has now become the form of establishing parenthood through intention. So adoption is no longer the exception, but the form. So this is Professor Robinson's loop back at work. If this is indeed our future, it may be impossible to recover an understanding in law in which adoption retains both its character of self-gift and serves the child rather than primarily the needs of adults. Nevertheless, I continue to believe there are ways in which law as teacher can promote adoption as a meaningful choice for women facing an unexpected pregnancy, as a more likely outcome for children languishing in foster care, and to encourage families to welcome children in need, and thereby, hopefully, to remind us all of the priority of the child. In closing, I will just share 2 examples of efforts I've been involved with as examples from my work. One way the law can help is to require accurate information to be provided to women in all contexts in which it might be relevant, so that she understands that adoption is an option. So, for example, those of you who are law students know that while the common law of every state requires a patient to be apprised of the nature and risks and benefits or alternatives, this is known as the informed consent process before a medical procedure. So just over 30 states have explicit laws specifying what information has to be provided to a woman in the context of an abortion. Less common are laws that require women to be provided in this context with information about adoption. And even where they do require this information, they are often ill-designed or poorly executed. So I'll just give you an example. Until recent legislative action, the informed consent materials on the Louisiana State Health Department website directed women, as part of the informed consent process, to a separate page that featured the phrase adoption services. But if a woman clicked on that link, it took her to a new page with 2 more links. One of those links was about safe havens, which are the laws that allow parents to anonymously drop a baby off at a safe location like a fire department, and provide for that process. The second link was to the State Department of Children and Family Services webpage. That's the agency that administers foster care. And ironically, in Louisiana, the state DCF is not actually allowed to take voluntary placements of children. They only process involuntary removals. So neither of those links served to educate a woman more about what adoption actually involved. So I brought this situation to the attention of policymakers in Louisiana, and as a result, the coalition sought to amend the law, eventually passing the Adoption Option Act. And now Louisiana's Department of Health website contains really beautifully presented, accurate, non-coercive information about adoption, and also guarantees that materials be distributed to women as part of the informed consent process in abortion facilities. And encouraged by the example of Louisiana, legislators last year passed a similar law in Arizona, and I provided legal testimony to the Arizona House of Representatives in support of that legislation. Turning last to the seemingly intractable problems in child welfare and the difficulty in recruiting and retaining adoptive and foster parents, it's very difficult to suggest a reform of a one-size-fits-all nature. Scholars like Harvard's Elizabeth Bartholet or the late Professor Richard Gellis from Penn argue that the main problem with the child welfare system is that it prioritizes the needs of adults rather than the safety and stability of children. So Gellis calls for child welfare laws to treat the child as the client, to make decisions with the child's safety and well-being as the most important goal, and to make decisions with a child's sense of time. Enforcing laws like the 1522 rule with more rigor and consistency would go a long way to remedying this situation. But to give an example of something that I've contributed in this area, amidst these systemic barriers, I believe an important role of law is to ensure that faith-based providers may serve in the child welfare sphere amid the various legal and social pressures to drive them out. This is important, I think, because faith-based child placement service providers are uniquely effective in the child welfare sphere. For example, a literature review published this year by the American Psychological Association found evidence that faith-based foster care and adoptive organizations may be particularly helpful for recruiting and training families to care for orphaned and vulnerable children. So along with another professor and several faith-based child welfare organizations, I filed an amicus brief in Fulton v. Philadelphia, arguing that faith-based agencies should not be excluded from the field of child welfare, but should be permitted to contribute to the diversity of providers for the benefit of children. We argue that faith-based agencies are effective recruiters precisely because they are faith-based. Such organizations provide wraparound services that are so critical for children and for retaining foster families, and they are uniquely suited to doing so because they excel at forming the sort of network that helps interested caregivers make it through the significant challenges. As we put it in the brief, the cliche is true. It takes a village to raise and then we put in brackets, foster a child. Faith-based agencies, themselves corporate expressions of shared religious belief, are designed to create and sustain the village. That is because faith communities already are villages. So amidst of all the pressing challenges besetting child welfare, I would argue that we need every pair of hands on deck serving vulnerable children and families. So I think the common thread with these examples, and I hope with other of my work, is the robust support for adoption as a safety net that is child-centered and that meets a real human need, providing a home for a child who lacks one. So to conclude, those are the favorite words of an audience. I would like to reflect once again on the example of Mary, for whom this lecture is named. Years ago, I encountered in a special way a beautiful sculpture of the crucified Christ with Mary and John at the foot of the cross. And in this particular sculpture, Jesus was leaning forward from the cross toward Mary, who stood with her arms and hands open, a physical posture of orientation to the other and receptivity. And John stood next to her with his head bowed reverently. And we know from Scripture that this captures the moment at which Jesus said to his mother, "Woman, behold your son," and to John, "Behold your mother." And Catholics understand these words to be the moment at which Jesus gave Mary to all of us to be our mother. But this deeply moving moment was also what Pope Benedict XVI called an entirely human gesture on the part of the dying Savior. An adoption arrangement, he called it, in which Christ placed his mother in the custody of the disciple who was especially close to him. And so a new home is also given to the disciple, a mother to care for him, a mother for him to look after. Just as Pope John Paul called adoption an exchange of gifts, so this gift of motherhood and sonship at the foot of the cross demonstrates beautifully how all those involved in adoption are knitted together by a sacrificial act of love. In Amoris Laetitia, Pope Francis said, "The choice of adoption and foster care makes people aware that children, whether natural, adoptive, or taken in foster care, are persons in their own right who need to be accepted, loved, and cared for, and not just brought into this world." Every one of us is made from love and for love, and so as an expression of gratitude, we have a duty to practice radical hospitality and to welcome the stranger. So it is my hope that more people will see adoption as a way of practicing radical hospitality to the modern orphan, the child at risk of abortion, and the child languishing in the foster care system. Thank you.
Thank you, Professor Kirk, for your remarks.
On behalf of the JP2 Guild of Catholic Lawyers, we're honored to present to you the Mary Mirror of Justice Award. We appreciate your commitment to truth, justice, and Catholic virtues. As Director of the Center of Law and the Human Person, we thank you for recognizing the inherent human dignity of every person and for bringing important topics to bear on our education at the Columbus School of Law.
Everybody go eat.